Good morning.
Yes, good morning, and may it please the court. My name is William Keefe, and along with Mr. Michael Doolin, I represent Mr. John Taylor, the appellant in this case. And respectfully, Your Honors, Mr. Taylor's one of his principal arguments is that the board did not give due weight or consideration to the fact, a mitigating fact, that he self-reported his crime of delivering an article, a pair of sneakers, to an inmate, his client. This is the case that was in the Plymouth District Court. This was the case that was his lone felony conviction in this most recent bar disciplinary proceeding. There were some other crimes that he was convicted of, but those were all misdemeanors. It was this Plymouth District Court case, which is the felony conviction, and as the court knows, carries the presumptive sanction of disbarment. The facts of this Plymouth District Court case clearly involved the practice of law. Mr. Taylor was visiting the Plymouth County Jail to consult with one of his clients in a criminal case. The facts were that he brought with him, wearing on his feet, a pair of sneakers, walked into the attorney-client room, sat down with his client, and then exchanged the pair of sneakers. But
I take it wasn't by accident. It wasn't, geez, I like those sneakers. This was a plan to get these sneakers to him without going through the normal process. That's correct.
How long after that did he self-report?
Mr. Taylor testified that after he left the jail on the same day, while driving in his car, I think is the testimony, felt that it wasn't right and called the jail and essentially confessed what he had just done. Now, the board, I'd suggest respectfully, gave minimal significance or passing reference to this in its decision, and drawing the court's attention to the case law where the issue of whether an attorney's cooperation is a mitigating factor. Some of those cases are the Kennedy decision and the Consemi decision. I just want to point out that all of those decisions involved attorneys who, after having been investigated, after having been indicted, and after having been in the defendant's dock facing federal prison time, made a decision, like many defendants do in federal court, to cooperate and finger others in an effort to lower their exposure and lower the possibility, or try to avoid a prison sentence. And this is Mr. Taylor, who didn't do it after it was detected. This incident remained undetected after he left the jail. And as I mentioned earlier, he, on his own volition, called the jail and confessed what he had done.
Okay, but the problem, of course, with such smuggling is we don't know, or the danger of smuggling is potentially weapons or drugs could be smuggled in as part of the shoe. And I'm not suggesting that that's what he did here, but calling in afterwards to say you did it doesn't really eliminate, from the prison's point of view, the danger that has arisen. Is that now some illicit sneakers have come in with Lord knows what inside, and now they learn about it afterwards, and if there were anything inside, those would be gone. That's still a major problem for a prison to say, we don't know, these shoes have come into this guy, we don't know what's in them. And now, realistically, it's too late for us to address it because whatever was in them will be gone by the time they respond.
There is that consideration, Your Honor, and I do note, however, that I think the evidence was that the inmate was confronted, the shoes were taken from him, and there was no evidence that any contraband drugs or weapons.
So this is why he called up? He called up before the inmate was confronted? He
did, correct.
So I take it the hearing committee found that he had called essentially on his way, leaving the prison. So that's not a contested fact.
That's not contested, okay. Your Honor.
Let me ask you something else about all of these probation revocations. I'm not sure I have the sequence right. How many times was his probation revoked?
I would have to go through it with a fine-tooth comb, Your Honor. I know that he was placed on probation for operating with a suspended registration in 2007. And as a result of this complaint in the Dorchester case that ultimately went to trial, his probation was revoked on that driving offense.
But I thought it was even before that. Wasn't it revoked for other things?
There may have been some other bases for the probation surrender, including a failure to report to his probation officer.
Was it also not a failure to a failure? He flunked a drug screening as well, or
I believe that that came up, I think, later, Your Honor. In
different probation. Was it the same period of probation, or was that probation on a different case? I'm having a hard time, so I need a chart here.
Yeah, but I'm looking at the board memorandum, which I have in my hand, and I think that was a different probation out of Dorchester, where there was a determination that he tested positive for marijuana use. Okay. And I do know that there were 2 or 3 different probation surrenders that he was subjected to. With respect to this reporting this felony that he had committed, the board, in their decision, and it's transcript page 8, said that even if his change of heart should be viewed as a mitigating circumstance, he has not convinced us that his disclosure reflected anything more than a dawning realization that his crime would be discovered. That's how the board essentially treated what Mr. Taylor suggests is a significant mitigating factor. There is absolutely no support in the record, factually or otherwise, that Mr. Taylor did this because he had a dawning realization that the jail was going to find this out.
Well, excuse me, Mr. Keefe. No matter how we think about the swapping of the sneakers, you'll agree it was a felony.
It was, Your Honor. Yeah.
So are you taking the position that it's a mitigating circumstance that Mr. Taylor self-reported a felony? Or are you suggesting that because it was just sneakers, it was not as significant a situation?
I think it's both, and there are some other decisions. I think the Cohen decision and the Morass decision involved the delivery of narcotics and cigarettes to particular inmates in those cases by attorneys. I just respectfully argue that compared to the Kennedy and Consemi decisions,
did Mr. Taylor ever make any representation as to why he would switch shoes?
I don't know if this is in the record, but I believe he stated that the client's family had been asking him to bring a pair of sneakers to the jail for several weeks, and they were calling him on a daily basis, and to satisfy the client and the client's family, he did this. And after leaving the jail, made the phone call that he had done what he had done.
Well, so the family gave him some sneakers to give to an inmate.
Correct.
I mean, doesn't that raise some concerns about, whether there was contraband or anything in the sneakers?
It certainly does raise that concern, and the incident after Mr. Taylor reported it was investigated by jail staff. I think the evidence was that they went to the inmate. He had this.
By that point in time, there was no contraband.
Correct.
How much time passed between the swapping of the shoes and the officers, the correctional officers?
I believe he testified that it was the same day. I don't know that there was a specific number of hours. So Your Honor, I just note that many of these other misdemeanors were all motor vehicle type moving violations where operating after suspended licenses, and they reflect, I think, in many ways that Mr. Taylor at this time, his life was in disarray. I do note that despite being his own worst enemy, as you can read from the board memorandum, Mr. Taylor is in many ways was a remarkable rehabilitation story. And I can also note that no one in the defense bar, when he was practicing, was as passionate, committed, and zealous a defense lawyer than Mr. Taylor, and that he cared very much about his
What do
profession.
you say would be the appropriate sanction?
We've recommended a 2-year suspension, but I do note that the Kennedy decision, which took into account his cooperation, I think was an indefinite suspension that the court imposed. So, thank you.
Thank you, Mr. Keith. Good morning, Ms. Kaufman.
Your Honor, Nancy Kaufman for Bar Counsel. Well, it's true that at the hearing, Mr. Taylor testified that after he got home from Plymouth County House of Correction, he called. However, in his brief to this court, he wrote that he called the next morning. And he added to the appendix documents that were not in the record at the hearing, which show that he did not call until the next morning. So I don't think he should be getting too much credit for reporting this. It was at least several hours, according to his testimony at the hearing, and according to his brief and the documents that he provided to this
Well,
court.
regardless what it was, there was plenty of time for the inmate to have gotten whatever there was.
Exactly.
Because if anything, out.
He also wore the inmate's shoes out of the prison. So there were actually 2 felony convictions. So the danger is not only in bringing material into the facility, but in taking material out of the facility. That's why there are 2 felonies. Then there is the assault and battery, which was also in connection with the practice of law and numerous driving offenses. He was violated on probation at least 4 times. One of them did arise from the assault and battery charge, but the others were failure to report. He failed to appear at one violation of probation hearing. He flunked drug tests. He never took the anger management course that he was supposed to take. And he also tested positive for marijuana and opiates. That was as recently as the fall of 2009, which is why he did not get retroactivity to the date of his temporary suspension. Not only was he not permitted to go into the Plymouth House of Correction again, but the documents that he supplied to this court as part of the record in the case show that the client denied having received the sneakers from anyone, that they had been brought into the facility. He was written up on charges and was transferred to a different unit. So I don't think he's really taken into account the effect of his conduct on the client who was incarcerated in the prison. And I think we've also overlooked the fact that he does have a record of discipline, which reflects, well, that public reprimand involved his neglecting 2 clients, not returning the unearned portion of a fee to one of them, and then giving him a bad check to make restitution, and the client ended up having to sue him for the money.
Is there any discipline in any other state?
Like this?
No. Just discipline.
Oh,
For
this-
Taylor in any other
Has
state?
he been sanctioned in another jurisdiction?
Yes, that's what
I
I'm
don't
asking.
believe he's admitted in any other jurisdiction. He did not get admitted in Florida. I don't think he ever got admitted in Florida. So I would just say that it's a sad case. It does show that Mr. Taylor has had numerous opportunities to conform himself to the requirements of the profession and the law. He seems not to be able to do that. At some point, enough is enough, and disbarment is the appropriate remedy, and we would ask that you uphold the decision of the single justice.
Thank you, Ms. Kaufman.